I never thought I would become the person who actually reads HOA meeting minutes. But when you get a $2,000 fine for painting your front door the wrong shade of beige, you start paying attention real fast. My name is Henry Young, and I bought my house in Willow Creek Estates, a planned community just outside Charlotte, North Carolina, about 3 years ago. The neighborhood was perfect. Tree-lined streets, well-maintained common areas, and homes that all looked just different enough to avoid that creepy cookie-cutter feel. The HOA seemed reasonable during the buying process. Monthly dues were $150, the rules looked standard, and the real estate agent assured me they were not the nightmare type. She lied. It started small, like these things always do. First, it was a warning letter about my trash cans being visible from the street on a non-collection day. I had brought them in from the curb and left them on the side of my house, but apparently, you could see about 3 inches of black plastic from a specific angle on the sidewalk. Then came a citation because my lawn was a 1/4 inch too tall. I measured it myself after that letter. It was 3.5 inches. The HOA covenant specified a maximum of 3.25 inches. Who measures grass down to the 1/4 inch? But the front door fine was what pushed me over the edge. I had repainted my door during a weekend in April 2025. The original paint was peeling and it looked terrible. I went to the hardware store, found a color called desert sand that looked identical to what was already there, and spent a Saturday making my entrance look presentable again. 2 weeks later, I got a violation notice in the mail with a $2,000 fine attached. The letter stated that I had not received architectural approval before making an exterior modification, and the color I chose was not on the approved list. I was given 30 days to repaint the door in an approved color or face additional daily fines of $50. I called the HOA management company the next morning. A bored-sounding woman named Patricia answered and told me that all exterior changes, including repainting existing features, required prior written approval. When I pointed out that I had painted it the exact same color, she said it did not matter. Rules were rules. When I asked how to appeal, she said I could submit a written request to appear before the board at their next meeting, so I did. I wrote a detailed letter explaining the situation, included before and after photos that clearly showed no color change, and requested the fine be waived. I submitted it 3 weeks before the scheduled meeting in May, which gave them plenty of time to add me to the agenda. The meeting was held on a Tuesday evening at the community clubhouse. I arrived 15 minutes early and found about 8 other homeowners already there, all looking varying degrees of annoyed. The board consisted of 5 people seated at a long table at the front of the room. In the center sat Brenda Whitmore, the HOA president, a woman in her late 40s with the kind of severe blonde bob that screamed, "Let me speak to your manager." To her right was Gary Mitchell, the vice president, a retired accountant who looked like he had never smiled in his life. The other board members were Sharon Wells, treasurer, Doug Patterson, secretary, and Linda Huang, member at large. Brenda called the meeting to order at exactly 7 o'clock and immediately launched into a presentation about landscaping standards in the neighborhood. She spent 20 minutes showing photos of various violations, including several shots of my slightly too tall grass from March. My jaw clenched as I watched my house appear on the screen multiple times. When she finally opened the floor for homeowner comments, I raised my hand. She looked directly at me, frowned, and said they would address architectural violations at the end of the meeting. I sat back down and waited. They discussed playground equipment maintenance. They reviewed the pool schedule for summer. They debated the cost of repainting the clubhouse exterior, They argued about whether to allow food trucks at the 4th of July party. By 8:30, people started leaving. By 9, only 3 of us remained. Finally, Brenda addressed me. "Henry Young, regarding your door situation. The board has reviewed your request and voted to deny your appeal. The fine stands. You have 2 weeks remaining to repaint in an approved color. Next item." I stood up. "Wait, that is it. You did not even discuss it. I submitted my request 3 weeks ago." I included photos showing the color is identical. Brenda did not even look up from her papers. "The board deliberated prior to this meeting. Our decision is final. Can I at least present my case, explain the situation? The time for explanations was in your written request. We have reviewed it and made our determination. If you refuse to comply, the daily fines will begin and we can place a lien on your property." Gary leaned forward. "The architectural standards exist for a reason, Mr. Young. You cannot just make changes without approval. It creates chaos." "I painted my door the same color it already was." "That is not what our inspection showed," Brenda said coldly. "The previous color was Sahara Tan number 27. You used a non-approved color. The violation stands." I left that meeting furious. $2,000 because I made my door look less shabby in the exact same shade it had been for years. When I got home, I did something I had never done before. I went to the HOA website and downloaded every meeting minute from the past 2 years. If they were going to nickel and dime me over paint colors, I wanted to know what else they were up to. I started reading through the documents that weekend. Most of it was boring procedural stuff. Motions to approve this, votes to deny that. But as I cross-referenced dates and decisions, something started to feel off. In the March 2025 minutes, there was a recorded vote about hiring a new landscaping company. According to the document, the board had unanimously approved switching to Greenscape Solutions with a monthly contract of $8,000. But I remembered seeing something about landscaping in an earlier meeting. I went back to January 2025 and found it. The board had voted on landscaping then too, approving a company called Prestige Lawn Care for $6,000 per month. Both votes were recorded as unanimous. Why would they vote on landscaping contracts twice in 3 months? I kept digging. In the April 2025 minutes, the board had supposedly voted to table a discussion about speed bumps until May. But in the May minutes, there was no mention of speed bumps at all. Instead, there was a note saying the board had previously approved speed bump installation in February, and work would begin in June. I checked the February minutes. Nothing about speed bumps. The more I read, the more inconsistencies I found. Votes that appeared in minutes but contradicted earlier votes. Decisions that were recorded as unanimous, despite homeowners commenting about split votes in online community forums. Expenses that appeared in 1 month's minutes and then vanished from subsequent financial reports. Something was wrong. Very wrong. I started attending every board meeting after that. In June, I sat through another tedious session where Brenda and her board discussed pool rules and parking enforcement. During the homeowner comment period, a woman named Rachel Martinez asked about the landscaping contract. She wanted to know why the common areas looked worse despite the HOA hiring a more expensive company. Brenda responded that Greenscape Solutions was doing excellent work, and the board was very pleased with their services. Rachel pressed the issue, saying her neighbor worked for Prestige Lawn Care and mentioned they still had an active contract with Willow Creek Estates. Brenda cut her off, saying the neighbor was mistaken and the board had thoroughly vetted all contractors. After the meeting, I introduced myself to Rachel. We compared notes, and she showed me photos of prestige lawn care trucks working in the neighborhood as recently as last week. But according to the official minutes, Greenscape Solutions had been the exclusive contractor since March. "Something is definitely wrong here," Rachel said. "My husband thinks I am being paranoid, but the numbers do not add up." "They do not," I agreed. "Do you know anyone else who has noticed problems?" She did. Over the next 2 weeks, Rachel connected me with 4 other homeowners who had questions about various board decisions. There was Tom Brennan, who had been trying for 6 months to get approval for a solar panel installation that kept getting delayed for nonsensical reasons. Jennifer Wu had been challenging a fine for a decorative garden fence that she insisted was within covenant guidelines. Marcus and Deanne Thompson had received a violation notice for parking their boat in their driveway, despite multiple neighbors doing the same thing without penalty. We started meeting informally at a coffee shop on Sunday mornings. I brought my collection of meeting minutes, and we went through them line by line, cross-referencing with financial reports and community forum posts. The picture that emerged was disturbing. The landscaping situation was just the beginning. We found evidence of duplicate payments to multiple vendors, votes that changed between meetings without any recorded revisions, expenditures that appeared in minutes but not in financial statements, approved projects that never happened, denied requests that mysteriously became approved in later documents without any record of reconsideration. "They are changing the minutes after the fact," Tom said during one of our meetings in July. "Look at this." The June meeting minutes show they approved the playground renovation for $30,000. But the draft minutes that were posted online right after the meeting showed $45,000. Someone changed it. I had been taking screenshots of every document the HOA posted online, just in case. Tom was right. The draft version clearly stated $45,000. The final approved version said $30,000. But the actual invoice from the playground company, which I had obtained through a public records request, showed they had been paid $45,000. Where did the other $15,000 go? Jennifer pulled up the treasurer's reports. Look at the reserve fund balance. In January, we had $270,000 in reserves. By June, it is down to $190,000. But the minutes only show about $30,000 in approved expenditures from the reserve fund. We are missing $50,000. We were not just dealing with sloppy record keeping. This was fraud. The question was how to prove it without just our word against theirs. The board controlled all official records. They could claim our screenshots were fake or that we were misremembering discussions. We needed something concrete. That is when Marcus suggested we start recording the meetings. North Carolina is a one-party consent state, which meant as long as one person in a conversation knows about the recording, it is legal. Since board meetings were public forums for association members, we were well within our rights to record. At the July meeting, I placed my phone on the table in front of me with the voice recorder app running. Tom sat across the aisle with his phone doing the same. We wanted backup in case one device failed. The meeting proceeded normally. Brenda discussed pool maintenance issues and announced that the fall block party would be held on September 20th. Then, Gary brought up a vote about repairing the fence around the tennis courts. According to him, they had 3 bids and were recommending secure fence solutions for $18,000. "Is there a motion to approve?" Brenda asked. "So moved," Sharon said. "Second," Doug added. "All in favor?" Brenda asked. 4 hands went up. Linda Huang abstained. Motion passes 4-1. "Moving on," Brenda announced. After the meeting, I checked the draft minutes that were posted online 3 days later. The tennis court fence vote was recorded as unanimous, with all 5 board members voting in favor. There was no mention of Linda's abstention. I had it. Clear audio recording of the actual vote contradicting the official minutes, but I wanted more. One discrepancy might be explained as a clerical error. I needed a pattern. We recorded the August meeting as well. During that session, a vote about replacing the pool heater showed 3 members in favor and 2 opposed. The minutes recorded it as unanimous. A discussion about allowing residents to rent the clubhouse for private parties included Brenda specifically saying they would table the decision until September. The minutes stated the board had approved clubhouse rentals effective immediately. By September, we had recordings of 3 consecutive meetings showing systematic falsification of the official record. We also had financial documents showing significant discrepancies between reported and actual expenditures. It was time to confront them. I requested a special meeting with the board, citing concerns about financial irregularities. Brenda tried to deny the request, but HOA bylaws stated that any homeowner could request a special board session with at least 5 business days' notice. I submitted my request in writing, with copies to all board members on September 3rd. They had to meet with me by September 10th. The meeting was scheduled for September 9th at 7 p.m. I brought Tom, Rachel, Jennifer, and Marcus with me. Brenda looked annoyed when we all walked in together. "This is a meeting with Henry Young, not a town hall," she said sharply. "They are here for moral support. Bylaws do not prohibit other homeowners from attending board meetings," I replied. She pressed her lips together but did not argue. "Fine. You requested this meeting. State your business." I laid out our findings: the inconsistencies in meeting minutes, the financial discrepancies, the votes that changed between draft and final versions. I played audio clips from recent meetings showing votes that contradicted official records. I presented bank statements and vendor invoices that did not match reported expenditures. As I spoke, I watched their faces. Gary's expression went from annoyed to very pale. Sharon kept glancing at Brenda nervously. Doug stared at the table and would not make eye contact. Linda looked genuinely confused, like she was hearing much of this for the first time. Only Brenda maintained her composure, though her jaw was clenched so tight I thought her teeth might crack. When I finished, I set down a thick folder of documentation. "I am giving the board 1 week to voluntarily resign and turn over all financial records for an independent audit. If you do not, I will be filing a complaint with the North Carolina Secretary of State and retaining an attorney." Brenda stood up abruptly. "This meeting is over. Your accusations are baseless and frankly slanderous. The board operates with complete transparency and integrity. If you do not like how we run things, you are free to move to a different neighborhood." "So you are refusing to address any of these concerns?" I asked. "There is nothing to address. You have taken legitimate board business and twisted it into some conspiracy theory because you are still upset about your door fine. This is harassment, Mr. Young. I suggest you stop before you find yourself facing legal action from the board." I have recordings that prove the minutes are false. Those recordings, if they exist, only prove that you do not understand proper parliamentary procedure. Doug sometimes corrects the record after meetings based on his official notes. That is standard practice. Doug finally looked up. "Brenda, she cut him off with a sharp look. "This meeting is adjourned." We left without another word. In the parking lot, Rachel turned to me. "What now?" "Now we file complaints and get a lawyer." The next day, I submitted a formal complaint to the North Carolina Secretary of State's office detailing the financial irregularities and providing copies of all our documentation. I also filed a complaint with the North Carolina Real Estate Commission, which has oversight of HOA management companies. Then, I started calling attorneys who specialized in HOA disputes. The third lawyer I contacted, a woman named Sarah Chen, agreed to take the case. She had handled several HOA disputes and was very interested in the evidence we had compiled. "This is actually quite serious," Sarah said during our first meeting. "Falsifying corporate records is illegal. If the board has been misappropriating funds, we are potentially looking at fraud and embezzlement. Beyond just civil liability, there could be criminal charges." "So what are our options?" Tom asked. He had come with me to the consultation. "We file a lawsuit on behalf of the Homeowners Association members against the board for breach of fiduciary duty, fraud, and misappropriation of funds. We will request an injunction to freeze HOA funds and remove the current board pending investigation. We can also request the court dissolve the board entirely and appoint a receiver to manage the association's affairs temporarily." "How long does something like this take?" I asked. "Depends on how they respond. If they fight it, could be 6 months to a year. If they realize they are caught and do not contest, maybe 2 to 3 months. Either way, once we file, things are going to get very unpleasant in your neighborhood." She was not kidding. We filed the lawsuit on September 23, 2025. Within days, every homeowner in Willow Creek Estates received a letter from the board calling me a disgruntled resident trying to sabotage the community. The letter claimed I was filing a frivolous lawsuit because I was angry about legitimate fines for violations. It urged homeowners to ignore my conspiracy theories and support their elected board. My email inbox filled with messages. Some were supportive, thanking me for standing up to the board. But others were hostile, accusing me of wasting HOA money on legal fees and causing problems over nothing. Someone left dog poop on my doorstep. Another neighbor stopped talking to me entirely. The hearing for our injunction request was scheduled for October 15th. Sarah had filed an emergency motion to freeze HOA assets and temporarily suspend the board's authority pending investigation. Judge Robert Morrison would be presiding. The day of the hearing, I wore my best suit and arrived at the courthouse 30 minutes early. Sarah met me in the hallway, carrying 2 large boxes of evidence. "Their attorney just tried to get the hearing postponed," she said. "Judge denied it. They are scrambling." The board's lawyer was a man named Paul Hendricks from a firm in downtown Charlotte. He looked expensive. When the hearing began, he immediately launched into an argument about how the lawsuit was filed improperly and should be dismissed. Judge Morrison was not interested. "Mr. Hendricks, I have reviewed the complaint and supporting documentation. The plaintiffs have provided substantial evidence of irregularities that warrant investigation. Unless you have evidence that directly refutes their claims, I am inclined to grant the injunction." "Your Honor, these so-called irregularities are simply misunderstandings of standard HOA procedures. My clients have operated this association professionally and ethically for years. This is a personal vendetta by a homeowner upset about legitimate fines." Sarah stood. "Your Honor, if I may. We have audio recordings of board meetings that directly contradict official meeting minutes. We have financial records showing expenditures that are not reflected in the association's books. We have evidence of votes being changed after the fact. This is not a misunderstanding. This is systemic falsification of corporate records." She approached the bench and handed the judge a tablet with audio files queued up. "If the court would indulge me for just 3 minutes, I can demonstrate the problem." Judge Morrison nodded. Sarah played the recording from the July meeting showing Linda Huang abstaining from the fence vote. Then she displayed the official minutes showing a unanimous vote. She repeated the process with 2 more examples from August and September. The judge's expression grew progressively more grim. When the 3rd clip finished, he looked at Paul Hendricks. "Counselor, how do you explain these discrepancies?" Paul had clearly not expected Sarah to play the recordings in court. He stammered for a moment. "Your Honor, I would need to review the specific recordings and consult with my clients about the circumstances before I could provide an adequate explanation. Then I will give you that opportunity. But in the meantime, I am granting the plaintiff's motion for preliminary injunction. Effective immediately, the Willow Creek Estates HOA Board is prohibited from spending any association funds beyond routine operational expenses without court approval. All financial records are to be turned over to a court-appointed forensic accountant within 10 business days. The board is prohibited from holding meetings or making any decisions regarding association business without supervision." Hendricks stood quickly. "Your Honor, that effectively renders the board unable to function." "Yes, Mr. Hendricks, that is precisely the point. When a corporate board is accused of falsifying records and financial fraud, the court does not allow them to continue operating unsupervised. If your clients believe these accusations are baseless, they will have the opportunity to prove that during the full hearing. Court is adjourned." We had won the first round. Over the next 2 weeks, the court-appointed forensic accountant, a man named Richard Lopez, began digging through the HOA's financial records. Sarah had also filed discovery requests demanding documents, emails, and all original drafts of meeting minutes. The board tried to stall. They claimed they could not find certain records. They said their email server had crashed and some correspondence was lost. They insisted that draft minutes were never retained after final versions were approved. Judge Morrison was not having it. He issued an order compelling full disclosure and threatening contempt charges if the board did not comply. Finally, in early November, they turned everything over. Richard spent 3 weeks analyzing the records. What he found was worse than we had suspected. Over the course of 2 years, approximately $140,000 had been siphoned from the HOA's accounts through various schemes. The landscaping contract was part of it. The HOA was paying Greenscape Solutions $8,000 per month, but Prestige Lawn Care was actually doing the work for $6,000 per month. Someone was pocketing the $2,000 difference. Similar schemes existed with the pool maintenance contract, the security patrol service, and several repair vendors. Meeting minutes had been systematically altered to hide these arrangements. Votes that questioned contracts were changed to appear unanimous. Homeowners who raised concerns at meetings found their comments omitted from the official record. Financial reports were manipulated to show lower expenditures than actually occurred. The most damning discovery was a series of emails between Brenda Whitmore and Gary Mitchell discussing how to hide payments to a shell company called Creekside Management Solutions. It took Richard a while to trace it, but Creekside Management Solutions was registered to Gary's wife, Paula Mitchell. The company did nothing except receive money from the HOA and then transfer most of it to various personal accounts. Richard presented his findings to Judge Morrison on November 20th. Based on the report, the judge ordered the board to appear for a hearing on December 3rd to show cause why they should not be held in contempt and referred for criminal prosecution. That hearing was intense. All 5 board members sat at the defendant's table with Paul Hendricks, who looked like he wanted to be anywhere else. Sarah presented Richard's findings in detail, walking through each fraudulent transaction and showing how the meeting minutes had been altered to cover them up. When she finished, Judge Morrison looked at the board. Does anyone wish to respond to these allegations? Linda Huang raised her hand slightly. Your Honor, I had no knowledge of any of this. I have been on the board for less than a year, and I trusted the other members to handle financial matters appropriately. When I voted or abstained on issues, I assumed the minutes would reflect my actual votes. I am horrified to learn they did not. The judge nodded. Miss Huang, based on the evidence presented, you do not appear to be involved in the fraudulent activity. However, you did serve on a board that failed in its fiduciary duties. The other members, do you have anything to say? Doug Patterson spoke next. Your Honor, I also was not aware of the full extent of what was happening. I kept minutes as instructed by President Whitmore. If she told me to make changes, I assumed it was proper. I understand now that I should have questioned more, but I did not knowingly participate in fraud. Judge Morrison did not look sympathetic. Mr. Patterson, you are the secretary. You are responsible for maintaining accurate records. Claiming you were just following orders is not a defense. Brenda remained silent. Gary stared straight ahead. Sharon looked like she might cry. Paul Hendricks stood. Your Honor, my clients maintain that while there may have been accounting irregularities and some procedural mistakes in recording minutes, there was no criminal intent. They are willing to resign from the board and cooperate fully with any restitution requirements. Accounting irregularities, Sarah said incredulously. Your Honor, we are talking about $140,000 stolen from homeowners through elaborate schemes involving fake companies and falsified records. That is not an irregularity. That is organized fraud. Judge Morrison held up his hand. I have heard enough. Here is my ruling. Based on the evidence presented, I find that the Willow Creek Estates HOA board engaged in systematic fraud, breach of fiduciary duty, and falsification of corporate records. The board is hereby dissolved effective immediately. All 5 members are permanently barred from serving on any HOA board in North Carolina. Brenda finally reacted, her face flushing red. You cannot do that, Mrs. Whitmore. I would advise you to remain silent. I am also ordering that full restitution of $140,000 be paid to the Willow Creek Estates HOA within 90 days. The payment will be the joint and several responsibility of Brenda Whitmore and Gary Mitchell, as they appear to be the primary architects of this scheme. Furthermore, I am referring this matter to the Mecklenburg County District Attorney's Office for criminal investigation. Gary stood up suddenly. Your Honor, I want to make a statement. Brenda approached me 2 years ago with this scheme. I went along with it because she convinced me we deserved compensation for the work we did managing the association. I know it was wrong. I am prepared to cooperate fully with authorities and testify against Mrs. Whitmore if necessary. Brenda turned to him, fury in her eyes. You spineless coward. The judge slammed his gavel. Order. Mrs. Whitmore, one more outburst and you will be held in contempt. This court is appointing a professional management company to oversee Willow Creek Estates HOA affairs for the next 6 months, during which time the homeowners will elect a new board under proper supervision. All legal fees incurred by the plaintiffs in bringing this action are to be paid by Mrs. Whitmore and Mr. Mitchell personally, not from HOA funds. This court is adjourned. As we left the courtroom, I felt a weight lift that I did not even know I had been carrying. Tom clapped me on the shoulder. Rachel was actually crying with relief. Sarah looked satisfied. What happens now? Jennifer asked. Now the criminal justice system takes over, Sarah explained. The DA will review the evidence and likely file charges. Based on what we have, I would expect charges of fraud, embezzlement, and falsifying business records at minimum. They are looking at serious prison time if convicted. Sure enough, on December 16th, the Mecklenburg County District Attorney's Office announced that Brenda Whitmore and Gary Mitchell had been indicted on multiple felony counts, including obtaining property by false pretenses, embezzlement, and conspiracy to commit fraud. Sharon Wells was charged with being an accessory after the fact. Doug Patterson was offered immunity in exchange for testimony. Linda Huang faced no criminal charges. Brenda and Gary were arrested at their homes early in the morning. The local news covered it, showing footage of them being led out in handcuffs. The story ran with the headline, "HOA board members arrested in $140,000 fraud scheme." Suddenly, our little neighborhood drama was public news. The trial took place in March 2026. I attended every day, sitting in the gallery and watching as prosecutors methodically presented the evidence we had worked so hard to compile. Doug testified about how Brenda had instructed him to alter minutes. Richard Lopez walked the jury through the financial fraud. I testified about discovering the initial discrepancies and how my attempts to raise concerns had been shut down. The defense tried to argue that Brenda and Gary had simply made poor business decisions and that there was no criminal intent. But the emails were damning. There was one where Gary explicitly wrote, "We need to make sure the minutes do not show the real numbers," and another where Brenda said, "As long as we control the records, no one can prove anything." The jury deliberated for less than 4 hours, guilty on all counts. At sentencing in April, Brenda received 5 years in prison and was ordered to pay restitution of $100,000. Gary received 4 years and owed $40,000. Sharon got 2 years probation and a $10,000 fine. All 3 were permanently banned from serving on any corporate or nonprofit board. Back in Willow Creek Estates, life slowly returned to normal. The professional management company the court had appointed actually did a great job. They fixed issues that had been neglected for years, renegotiated contracts to save money, and brought actual transparency to the process. In January 2026, we held elections for a new board. Tom was elected president. Rachel became treasurer. Jennifer, Marcus, and 3 other homeowners filled the remaining seats. Linda Huang chose not to run again, and honestly, no one blamed her. The new board's first action was to vote unanimously to rescind all outstanding fines that had been issued under questionable circumstances. My $2,000 door fine disappeared. So did dozens of other petty violations that Brenda had used to maintain control and generate revenue. They also revised the covenant enforcement procedures to require photographic evidence, clear measurements, and an appeals process that did not involve just asking the board that issued the fine to reconsider. Architectural approvals were streamlined with objective criteria, instead of subjective judgments. By the time summer 2026 rolled around, Willow Creek Estates actually felt like a community again, instead of a dictatorship. People were not afraid to paint their doors or park their boats or plant flowers without worrying about arbitrary fines. The common areas looked better than ever because we hired legitimate contractors who actually did the work they were paid for. I ran into Doug Patterson at the grocery store one day in June. He looked older, tired. When he saw me, he stopped like he was considering whether to walk the other way. Instead, he approached. "Henry, I owe you an apology," he said quietly. "I should have stood up to Brenda years ago. I knew something was not right, but I convinced myself it was not my problem. You did what I should have done." I did not know what to say at first. This man had helped falsify records that cost homeowners thousands of dollars, but he also had testified truthfully when it mattered. I appreciate that, Doug. For what it is worth, I believe you when you say you did not realize how bad it was. He nodded. I am moving, actually, selling the house. I cannot stay here anymore. Too many people know what happened and they should be angry. I just wanted you to know that what you did, standing up like that even when it would have been easier to just pay the fine and move on, that took real courage. The neighborhood is better off because of you. He walked away before I could respond. I never saw him again. As for me, I stayed in Willow Creek Estates. I love my house, my neighbors, and my slightly too beige front door that I can now paint any color I want as long as it is not neon or reflective. The neighborhood kids play in common areas that are actually well maintained. The pool is clean. The clubhouse hosts movie nights and potlucks. The new board actually reads emails and responds to concerns. Every time I drive through the entrance with its brick columns and professionally landscaped median, I think about how close we came to just accepting Brenda's corruption as normal. How many people paid fines they did not deserve because they were afraid to challenge authority? How much money would have been stolen if someone had not started reading the meeting minutes and asking questions? The whole experience taught me something important about community and responsibility. HOAs exist to maintain property values and manage shared spaces. When they work properly, they make neighborhoods better. But they are also corporations with real power over people's homes and lives. That power attracts people who want to exploit it. The only defense is engagement, transparency, and a willingness to challenge things that do not make sense. I never wanted to be the guy who fought his HOA. I just wanted to live quietly in my house and not get ridiculous fines. But sometimes doing the right thing means becoming someone you never expected to be. It means reading boring meeting minutes and recording meetings and filing lawsuits and sitting through trials. It also means building community with people like Tom, Rachel, Jennifer, and Marcus, who were willing to stand up together when one person alone would have been dismissed. We formed friendships through that fight that I know will last for years. We created a neighborhood where people actually know each other and look out for one another. On a warm evening in July, the new board held a community barbecue at the clubhouse. Hundreds of people showed up. Kids ran around playing tag while adults ate burgers and talked about normal things like sports and vacation plans. Tom stood up on the clubhouse porch and thanked everyone for their patience during the transition. A year ago, most of us did not trust our HOA board, and for good reason, he said. Today, I hope we are building something different, a board that actually serves the community instead of ruling over it. That means we need your participation. Come to meetings, ask questions, hold us accountable. That is how we make sure what happened before never happens again. People applauded. Rachel caught my eye from across the lawn and raised her beer bottle in a toast. I raised mine back. Later, as the sun was setting and the crowd began to thin, a woman I had never met before approached me. She was probably in her 30s, had just moved to the neighborhood a few weeks earlier. "You are Henry Young, right?" she asked. "I heard about what you did, standing up to the old board. I just wanted to say thank you. My husband and I almost did not buy here because of the HOA horror stories we read online. But then we learned about the changes and the new leadership, and it convinced us to take a chance. I am glad we did." "Welcome to the neighborhood," I said. "I think you will like it here." She smiled and walked back to her family. I stayed for a while longer, watching kids chase fireflies in the dusk and neighbors laugh together. This was what a community was supposed to feel like. Safe, welcoming, fair. It had taken a lawsuit, criminal trials, and months of stress to get here. But standing there in the summer evening, watching my neighborhood be the place I had thought I was buying into 3 years ago, I knew it had been worth every difficult moment. My phone buzzed with a text from Sarah Chen. Restitution payment cleared. HOA account fully restored. You did good work, Henry. I smiled and put the phone away. The fight was finally completely over. Brenda was in prison. Gary was in prison. Sharon was on probation. The money was returned. The board was dissolved and replaced. Justice in every sense of the word had been served. I walked home as the streetlights came on, past houses with front doors painted in every approved shade of beige and tan and cream. My own desert sand door glowed warm in the porch light. I had never repainted it after all the drama. It seemed fitting somehow. That door had started a chain of events that changed everything. As I unlocked it and stepped inside, I thought about all the people living in neighborhoods across America dealing with petty tyrants on HOA boards. People who got fined for toys in their yards or grass a quarter inch too long or doors painted the wrong shade of beige. I hoped some of them would read about what happened in Willow Creek Estates and realize they did not have to just accept it. That records could be examined, questions could be asked, and boards could be held accountable. Change was possible. Justice was possible. It just required someone willing to read the meeting minutes and notice when things did not add up. Someone willing to record meetings and document discrepancies and file lawsuits, even when neighbors left dog poop on their doorstep. I had never wanted to be that someone, but I was glad I had been. Because now, dozens of families could live in their homes without fear of arbitrary fines or corrupt boards. Now, kids could play in well-maintained parks funded by money that actually went where it was supposed to go. Now, a community could be what it was always meant to be. I settled onto my couch and turned on the television, just another quiet evening at home. Outside, Willow Creek Estates hummed with the peaceful sounds of a neighborhood at rest. Somewhere, Brenda Whitmore was in a prison cell thinking about the consequences of fraud. Gary Mitchell was doing the same. And here, in the homes they had tried to control and exploit, life went on better than before. My $2,000 door fine seemed like such a small thing now. Just paint on wood. But it had been the crack that exposed the foundation rot underneath. Sometimes the smallest injustices reveal the biggest corruption. Sometimes painting your door leads to dissolving an entire board and sending people to prison. I would never look at HOA meeting minutes the same way again. And that was exactly as it should be.